Hello YouTube, Salivate Metal here. The news cycle has been anything but boring lately, and most of it has revolved around politics, mainly centered on the Trump administration. And this week in particular, the news cycle is focused on the hearings for Neil Gorsuch as Supreme Court Justice to replace Antonin Scalia. A wise choice for a very qualified member. And this it's going to come to a head, though, with the Democrats filibustering, forcing the Republicans to use what's known affectionately as the Harry Reid rule. That's right, the precedent set up as an unfair measure by the Democrats is now being used by the Republicans, and more than likely we will have a new Supreme Court justice by the end of the week. The reason why this is important is because there's a case to be heard on April 13th, and they can decide whether to hear the 1933 Double Eagle case. This article from Coin World, and it's quite a fascinating story. So I think I'm just going to go ahead and read from the article to kind of as a backstory, because I think this is just a fascinating saga, and it talks about private property and rights. And I think that certainly when Mr. Gorsuch sits on the bench, it's going to make a difference as to how this thing hears out. There are rules. It'll be quite interesting indeed. The Langford family's quest to keep 10 1933 St. Gaudens $20 double eagles will reach what may be its final step on April 13th, when the Supreme Court will consider whether it will hear the case. Barry Burke, the Langford's attorney, filed the petition for a writ of certiorari, if I'm pronouncing that correctly, on October 28th of 2016, asking the nation's highest court to overturn a district and an appellate court who found that the family's 10 1933 Double Eagles were stolen government property. The government responded to the family's petition on March 8th, requesting that it be denied, which would result in the government keeping the coins. The Langford family filed a response on March 20th, reiterating past arguments and warning that if the current ruling is not reviewed, the government will thus have vastly expanded powers to seize and retain property, powers not enjoyed by private property owners, and powers unconstrained by the very rules Congress enacted to rein in government overreaching in this precise context. On March 22nd, the Supreme Court reported the case as being distributed for conference on April 13th. When the case is docketed at the Supreme Court, it is eventually distributed for a conference, typically on a Friday, where the court discusses some, but not all, the petitions distributed during the conference. Petitions not discussed are automatically denied. The odds are not in favor of the Langford, since the Supreme Court only hears a small portion of the cases presented before it. It receives approximately 7,000 to 8,000 petitions for a writ of certiorari each term, and the court grants and hears oral arguments in about 80 of those. More than gold coins, the case has moved beyond the 10 coins that were allegedly found by Joan Langford in her family's safe deposit box in 2003, and now revolves around two key questions with broad implications. The first question is whether, when the government seizes the property from private citizens and intends to retain it indefinitely, it can avoid the procedures, deadlines, and penalties set forth in the Civil Asset Forfeiture Reform Act of 2000 by merely asserting that the property was stolen from the government and declaring that it has no intention of seeking forfeiture. The second question is whether the government can avoid CAFRA's protections by strategically waiting for years and then filing a declaratory judgment claim that seeks essentially the same relief as barred by CAFRA. In its October 28th petition, the Langfords warned that if the appellate court's decision is left to stand, the government will now be free in every case involving allegedly stolen government property to seize and keep that property without following CAFRA's dictates. And it kind of reminds me of Junius's last video about the executive orders and how the government could seize gold and what would happen if that occurred today. The coins were among 445,500 double eagle struck in the Philadelphia Mint, and most were melted. A few escaped, including 10 that were discovered by Joan Langboard in the family safe deposit box. In a January interview with Coin World, her son Roy said that the double eagles were among coins and other items that had been in the box since the 50s. He said that his mother told him to leave the coins in the box. She told him, "Put them back and you deal with it after my death." The coins initially belonged to his grandfather, Israel Izzy Swift, a dealer who frequented the Philadelphia Mint in the 1930s. Swift acknowledged to his Secret Service agents in the 40s to selling other examples of the 1933 Double Eagle, 9 of which were then tracked down by agents and confiscated or acquired by the government in the 1940s and 50s and subsequently destroyed. The Langboards voluntarily turned the coins over to the U.S. Mint for authentication. In 2005, the family was told that the coins would be retained by the Mint and would not be the subject of forfeiture proceedings. The next year, the family filed a civil action against the government to recover the coins, and in 2009, District Court determined that the government had two choices: return the coins to the family or initiate a judicial forfeiture proceeding. On July 20th in 2011, a jury ruled in favor of the government in a Philadelphia District Court, and this decision was later overturned by the appeals level by a 3-judge panel. The case was then considered by the full panel of the Third Circuit Court of Appeals, who agreed that the District Court that a seizure alone does not initiate a forfeiture proceeding because it does not necessarily mean that a transfer of legal title took place. In its August 1st, 2016 decision, the appeals court found that the government repossessed its own property and in doing so asserted its ownership rights to the coins. This may not be the final chapter on the coins, as Roy Langboard told Coin World, that the roster of known examples, which includes a Langboard 10, the coin that was authorized for public sale in 2002, and 2 additional ones housed in the National Numismatic Collection, of which I have seen actually in person at the Smithsonian Institution, likely will be added to by more examples awaiting discovery. He said, "I think everyone knows that there are others out there. They will resurface again." So quite interesting saga indeed, and how this all played out. Thought it was quite interesting that basically the government seems to have ruled first that they could keep them. It seems like a statute of limitations, but there's a lot of legalese here in this article that talks about it. But it survived, a couple generations there, and so in my view, they should let the family keep them. And but we shall see how this all plays out and see if the court will hear this case. But I thought it was quite interesting indeed, because the most expensive coin ever sold at auction was the only one that they thought was around, other than the 2 at the Smithsonian. And that one sold for over $7 million. And then they found these 10 and 2 years later. So quite interesting indeed. So post your thoughts below on this case. How do you think it'll end up? And would like to extend the multitude of gratitude y'all for watching, and encourage you to please rate, comment, and subscribe.